Hall & Wilcox acknowledges the traditional custodians of the lands on which this podcast is recorded. We pay our respects to their elders, past and present, and to all First Nations people joining us today.
Welcome to the latest Private Client podcast, Empowered Women, Wealth, Law and Legacy. My name is Juliet O'Brien and I'm a Senior Associate in the Private Client practice at Hall & Wilcox. We're a national practice and I'm based in Melbourne. This new series is all about empowering women to take control of their legal and financial futures. Whether navigating a relationship change, managing an inheritance, running a business or simply seeking some clarity in your affairs, this series is designed to really highlight some key matters and to help you make some informed decisions with confidence. The matters we will talk about in this series are not particular to women. They are common across women and men. However, in my experience and for the women I'm talking to in my practice, I've come to understand that there's a real appetite for some really great succession planning and wealth advice, tailored uniquely to a woman's perspective. My expertise lies in succession planning, wills, powers of attorney, dealing with the succession of a trust or a business and protecting assets, handling some disputes sometimes. And that's what this first episode is going to concentrate on. But in some later episodes, I'm going to be joined by other specialists in areas such as financial planning and family law and general wealth advice. They're all going to be women, all experts in their areas and also passionate about assisting other women. So today we're going to begin with succession planning, a topic that can be emotionally challenging, but which is really absolutely essential. And I'm really thrilled to be joined by my colleague Emma Woolley, a senior partner in our private client practice. Emma has extensive experience in advising clients in estate planning and estate administration with relation to trust structures, trust and estate disputes. And Emma is also the head of our family office advisory practice across the firm. Welcome, Emma.
Great to be joining you, Juliet, to discuss such an important topic. I know we would say this because this is what we both do for a living, but it really is that everyone will someday leave this world. And given that there is a 100% chance of dying, 100% of us, regardless of gender, should give some thought as to how they would like matters to be dealt with on their death. So everyone needs to get in shape to die. But Juliet, today we're going to be focusing on women and planning, as you said.
Thanks, Emma. You're really fortunate in our private client practice to have a large number of female lawyers, from graduate lawyers right through to very senior women partners.
Yeah, that's right, Juliet. This area of practice is really a deeply personal matter. And as with any occasion when you need professional advice, it's really important that you're able to build a relationship with those you choose to assist. So it's important that you can engage with people who have the right expertise, but also people that you feel comfortable to work with. There's some women, and this is some women, who feel that a female advisor might have a greater capacity to understand their unique and financial journey, such as career breaks for caregiving, longer life expectancy, gender pay gaps, and balancing family and financial goals. So some clients are more comfortable discussing these sorts of sensitive topics around relationships and cares and concerns about future asset protection and financial security for their families with another woman.
Yeah, I'm finding that too, Emma. And look, not only that, but we're seeing that women are inheriting more wealth than ever before. There's this intergenerational wealth transfer, which is happening at the moment, and it's going to continue to happen in Australia and the world for that matter over the next 20 years, given we've got baby boomers that are now in that generation that are facing their own mortality and passing their wealth to the next generation. But not only that, women are growing their own wealth like never before, and they're involved in business, they're starting their own businesses, they've become entrepreneurs. So they do need to make some decisions and really get some good advice around protecting their wealth and perhaps passing their wealth to the next generation. However, sadly, as you touched on, Emma, we're more than ever affected by divorce and separation currently in Australia. There's increasing numbers of divorce, and that also presents another lot of circumstances that women and men, for that matter too, are needing to navigate, and they can be sensitive topics. So there is a need to get the right advice and to have confidence in that advice. These changes are transforming professional, legal and financial advice that women need to be able to thrive. So, Emma, succession planning isn't just about legal documents. It's about helping women navigate change, isn't it?
That's absolutely right. We've touched on already that many clients come to us after a major life event, such as divorce or the death of a partner or receiving inheritance. And for some of them, this might be the very first time that they're managing significant assets or making really significant decisions alone. It can be empowering, but absolutely also can be overwhelming for many women. It's really challenging for anyone to have to face their own mortality. And it's not easy to think about what happens if you, say, lose the capacity to make a decision. But avoiding these issues or ignoring them can lead to really challenging consequences.
So there is a need to have a will to be able to deal with your assets when you're no longer here, to be able to look after them yourself. And as we touched on before, as we've touched on throughout this episode so far, it's never easy to look at your own mortality and consider what's going to happen when you're no longer here. It can be quite confronting. And that's probably the reason why there's a very large proportion of the Australian population who don't have a will. So they're really in immediate need of getting one done. But it's not only putting the will in place to start with, it's keeping it under regular review. And as we move through life, we need to review our circumstances, make sure that whatever structures we have in place are doing what we need them to do at that particular time in our life. So we need to make sure that whatever we have in place accurately depicts or encapsulates what our wishes are at that particular moment in time. Do you agree with that, Emma?
Yeah, absolutely, Julia. We very often meet people who have prepared a will. They tell us they prepared a will, but when we have a look, we see that this has been prepared maybe decades ago, even before they might have had children or entered into a relationship. And quite often this is done when they're in a rush, when they're heading overseas on a trip. So it's likely that there's been really significant changes in their life since they prepared that document, and significant changes perhaps in their assets. As you were saying before, wealth has changed over time. There's a significant build-up of wealth in the generations beyond baby boomers and baby boomers themselves. And building up and changing relationships, building up and changes in life and assets mean that it's really important that the plan that you did years ago is revisited to ensure that it remains current. It's particularly important, I think, also to review matters, any will that you've prepared, if there's been a change in the relationship. So in Victoria, getting married automatically revokes any existing will made before that marriage. So this means that if you had a will, that will is now no longer valid, and the person who made that will, if they die, they will be considered to be intestate if they haven't made a new one. So then their estate is distributed not in accordance with their wishes, but in accordance with what the legislation says around distribution on intestacy. There's some limited exceptions to that. So you can prepare a will which contemplates the idea that you might enter into a relationship, a marriage later on. And if you prepare your will on that basis, it won't be invalidated by that change in relationship status. The difference between marriage and divorce in the context of your will is that divorce doesn't in itself revoke your will. It does revoke automatically any provision you made in that will for a former spouse. But again, that might be your intention, but that might not be your intention. So the key is to ensure that you revisit these documents if you do have a significant change in relationship. And we're talking here about marriage and divorce, which is formal marriage and formal divorce. But very often people enter into relationships without the formality of marriage, and therefore there is no formality of a divorce. And if you do enter into a relationship, then you need to revisit these documents regardless of whether that's a marriage. So changes in relationship status must always be considered in relation to your will, but also in relation to other aspects of planning like powers of attorney or provision that you've made in relation to your superannuation. All of that stuff's important if you change your relationship status.
Yeah, I agree, but it goes further than that, Emma, doesn't it? Because quite often you might have appointed someone as to act as your executor of your will, which is the role of actually working out what assets and liabilities you have on death, and then getting a grant of probate if it's in fact required, and going through that process, you need to appoint an executor. It may be that the executor that you've appointed isn't able to act in that role anymore. They may not want the role, or they may have passed away, or they might have lost capacity and be unable to act. So that's certainly a matter that should trigger a review of your will. But your assets may have changed, and you may have other property that you wish to leave to a particular person that's not dealt with in your current will. You might also have children that have reached maturity that are now adults, and the last time you prepared your will, they were younger children and were unable to take a role under your will. So that can be a matter that needs to be reviewed. You might be part of the bank of mum and dad, and you might have some documentation that is detailing whether a loan has been made to one of the kids, and there might be now a need to deal with that loan in your will. Do you want to perhaps forgive the loan or release the loan upon your death? If you're going to do that, do you want to go further and perhaps equalise your estate between all of the children, so that the children that didn't receive the benefit of the loan or the gift are now being compensated for that as part of the will? You might have also have received an inheritance from a parent potentially, or someone else that now needs to be added to the assets that you are dealing with under the will. So these are all matters that happen throughout lifetime that can trigger a review of your existing document, including the death of a partner. That's probably one of the main things that we think about when we see a client, that they'll come in and say, look, I've recently lost someone. It does mean that I need to now review my documents just to make sure that I've got the right arrangements in place now that I no longer have that partner in my life. So at a minimum, we're talking about having a will in place, because a will does give you control. It prevents there being any uncertainty upon death, and it gives you the ability to be able to put the structuring of your affairs in place in the best way under your existing circumstances.
Yeah, Juliet, I think you're right. It's really important to have a will as a minimum as part of this planning. We've mentioned before that people do find contemplating their mortality challenging, and therefore find it difficult in some circumstances or some instances to face and manage putting in place an appropriate plan. But the way that we look at it is that it is challenging, but it is also a really positive step, and contemplating your mortality should therefore be a positive experience, because if you don't do that, then you're losing the opportunity to make the decision about how you want things to be managed. If you don't put in place a will, what you're doing is you're leaving it up to legislation to decide how things are transferred on your death. And so from a positive point of view, it's really important that you get the opportunity to do that, and therefore you take control of the situation. If you don't have a will, as I said, your estate will be distributed in accordance with the law, and those rules dictate who inherits your assets, with priority being given to close relatives, including surviving spouses and children, if you have any. If you've got other wishes or other concerns about how the things that you have built up over your lifetime are to be transitioned, then you should be taking control of that, and you should be making a will.
Absolutely right. And as I touched on before, one of the main things that you can do when you have a will is determine who will be in control of your estate when you die, and that's the appointment of your executor. If you do not have a will, someone that may not be the person that you would otherwise have appointed may well be the one that takes over and manages things. It's really important to have the will from that point of view. The other important factor to consider when you're looking at putting a will in place is that it gives you the opportunity to have testamentary trusts in your wills. And there are a number of advantages associated with testamentary trusts. The main ones being asset protection, some tax planning opportunities, and also giving you some greater flexibility and control over the way in which you're able to pass assets to the intended beneficiaries. So in terms of succession planning, we've talked about wills, but the other important piece to touch on today is the incapacity piece. And I'll ask you, Emma, just to talk to our audience about why that is so important.
Thanks very much, Juliet. I think that's right. It's absolutely important that we also consider what might happen and how we want things to be managed in circumstances where we lose the capacity to make a decision. So it's not certain that you will lose the capacity. It is 100% certain, as we said, that you will lose that you will lose your life one day. So it's critical that you make a will, but it's also really important that you consider putting in place documentation to deal with things if you lose the ability to make those decisions yourself. So the statistical information is such that there is a significant increase in people having a decline in cognition. So that might be as a result of illness, or it might be a result of accident, and quite commonly the result of genetic issues such as dementia and Alzheimer's disease. If you don't put in place documentation, then again, legislation gets involved and might dictate who gets to make decisions for you. And those decisions can include legal and financial decisions, so paying the bills and dealing with property if you lose the capacity to make a decision, but also really important decisions about consenting or refusing medical treatment on your behalf if you're unable to do that yourself, and making decisions about your welfare, including where you live. So decisions about whether you remain in your own home or whether or not that you move to some other form of accommodation. So these are really important decisions. And as I said, if you don't take the opportunity which is available to you, which is to put in place documents, powers of attorney, to make a decision about who you want to make those decisions, then you are in the hands of legislation. So the jurisdiction is the tribunal in Victoria, so VCAT gets involved, and it might be that people that you'd never contemplated or would like to make those decisions are appointed to do just that. So it is important you consider this as part of overall planning.
Thanks, Emma. A couple of things that we haven't touched on before we close out. I'd just like to talk briefly about family trusts and super, because there are other aspects of the succession planning piece that women do need to consider. Whatever's sitting in a discretionary trust or a family trust that may already be in existence, the assets held in those trusts do not form part of your personal estate and remain in a trust upon your death. So there is a separate piece of succession planning work that should be done in relation to those, just to make sure that the right people are put in control of your trust when you're no longer able to operate it yourself. Similarly with superannuation, it's important that if you have superannuation, that you make sure you've got what's called a death benefit nomination in place, which notifies or advises the trustee as to where you would like your superannuation paid to upon your death. So there are also important aspects of the succession planning piece that women should contemplate getting some advice around. So just in closing this episode, we've talked about a number of aspects that concern succession planning, and we really hope that they've resonated with our audience. Lots of things to consider. It's just important for us to get the message out there that they are important issues and everyone needs to contemplate them. But given the unique circumstances that many women face, it's particularly important that they're able to focus on them as well. If we don't put a plan in place, assets may go to unintended people, unintended beneficiaries. Family disputes can arise, and without a proper plan, decisions may be made by someone you wouldn't choose. So ultimately, it's about control and it's about protection. And it's also about peace of mind. Knowing that your affairs are in order is one of the most empowering things that you can do. So thank you, Emma. That wraps up our first episode. In our next episode, we're going to be exploring how women can take charge of their financial planning and build lasting wealth with our financial planner, Laura Pericini. Thank you for listening, and we look forward to speaking to you again in episode 2.
This podcast is not legal advice and should not be relied upon as such. You should always obtain legal advice about your specific circumstances.